this is more of the administrative side. Will you just frame the question so we're all on the same page before we start hearing from everyone?
Mr. Attorney?
Yes, sir. You have before you a recommended order. Your purview now of what you might consider does not include putting any additional evidence on the record. It is more like an appellate proceeding. The board needs to find that there's competent, substantial evidence in the record to support the administrative law judge's findings, and that you don't disagree, or maybe you do, but the other question is, did the ALJ follow the appropriate law? If you make a finding that there is competent evidence, and if you make a finding that the ALJ followed the appropriate law, then you ought to make a motion to approve the recommended order, and it will become your final order at that point. Conversely, if you don't find sufficient evidence, or if you disagree with the law, then you could, under limited circumstances, make a determination that the incorrect law was followed and reject the recommended order, in which case you'd be rejecting the development application.
So the question before the commission is not whether or not we like the proposed development, or whether or not we think that this is the appropriate development. The question before the commission is whether or not the ruling that came out of DOA followed all the rules and procedures, followed the law, and that we don't find fault in that process, therefore the final judgment as rendered by the judge.
Yes, that's correct.
Okay.
So procedurally, Mr. Attorney, each side gets 10 minutes, correct?
No, each side gets 20 minutes.
Each side gets 20 minutes, okay.
But because there are two petitioners, they need to divvy up their 20 minutes how they see fit.
Got it. So it's yours.
I mean, this has been a 4.5-year ordeal. I may very well ask for a brief extension. So, Mr. Chairman, members of the commission, thank you for the opportunity to speak this evening. This is what we're here about, is this relic that sits up on the Lake Jackson rim overlooking Tallahassee, and you can see the tree line as it's going down, and it connects into Lake Jackson. And so it was ultimately determined that this was a closed basin. Evidently, your staff didn't look at the historic photos. And so what that means is that when this is analyzed, you have, that's not going to show up very well, this is the only natural features inventory that's been conducted on this. This was done back in 2004 and finalized in 2007. Since that time, you have the road, Palafox Lane, that was built across the edge of the wetland. You have the homes that are built along the back that actually extend back into the wetland and extend in this entire area was required. I wish that would shine. The entire area of the wetland was set aside as a conservation easement by this commission. Conservation means conservation. It doesn't mean using it as a stormwater basin, which is what they're proposing to do here today. Please note that the properties along the back of that actually extend. That's their land. This line that separates right down the middle of the circle, that's the property line. All the property on that side of it belongs to the homeowners association. All the property on that side of it belongs to the developer. You'll note that in the front of this, right here, that this is set as a drainage easement. When you have people buying it and it shows that the entire front parcel is a drainage easement, people believe it's a drainage easement. It's only used as a stormwater basin. That's all it's ever been used for the last 12 years. Your staff did not require an amendment to the plat. So they're just ignoring the language on the plat. And that's your plat. The hearing officer said, oh, well, it says, note number 5 of the plat says, no permanent structures in any drainage easement. And the hearing officer says, oh, well, it doesn't mean this drainage easement, it just means the other drainage easements. It's kind of a preposterous situation. So the idea is that they want to go in and you see this big basin. It holds what's called the 100-year, 24-hour storm event. holds 10.7 inches of rain before it discharges into the wetland. And that's what we're here about, is that now they want to eliminate stormwater basin number 1, this one right here. They want to eliminate all of that, and they want to build 36 units on top of it. They don't want to retain any of their stormwater. They want to discharge it into the conservation easement. So basically, they want to use the conservation easement as a stormwater pond, knowing that it fills up. So here's their plan, is to build these units like this, and you can see that they only own to here. So when they discharge in here, they're actually discharging stormwater onto another citizen's land. They don't own it. They don't have an easement to it. They don't have a right to it. So that's why we're here, is we're saying you can't use our land. It's just that simple. You don't own it. You don't have a right to it. Stop. And staff just doesn't seem to understand why we have a problem with somebody dumping all of that water onto our land. And so you can see right here that they're going to they have the stormwater basin, you have a swale discharges into here, and they're going to now have this little pond. And understand that there's a big difference between the design of this. And this is all, I'm not changing anything from what was presented and what was done in the proposed, in the final order. So you have a 100-year, 24-hour storm event. That's 10.9 inches of rain. That is a fraction of what just happened in South Carolina and North Carolina, y'all. Okay, so if you approve this and you get something like, what was it, Hurricane Faye, 22 inches in a weekend. I was here for that. Unbelievable. Well, this isn't designed to hold that kind of storm back. You're dumping all the water on them. And so the difference is currently the existing pond has a capacity of 114,000 cubic feet. They're reducing it, this little one that's right here, that little one only has 45,000 cubic feet of storage, but it's temporary, okay? So one is called retain water. That means it only discharges in the 100-year, 24-hour storm event. This one is detention with filtration. So every bit of water that falls on this proposed site now goes through the stormwater basin, discharges out into the conservation zone. And that's not what y'all put the conservation zone in place for. The conservation zone is there for conservation. So stormwater treatment method versus retention versus detention with filtration. So the wetland has a calculated volume of 929,000 cubic feet. When it runs out, where does the water go? It goes through their neighborhood. So when the rain gets too much, it fills it up. It's just a bowl, y'all. And it has, when a bowl fills up, it goes over the rim. And when this one goes over the rim, it goes into these people's homes. It goes into their garages. It goes across their streets. You see those streets in South Carolina where they're collapsed? That's because it scours. This property, and you look at the data, drops over 40 feet from the edge of the rim to the back of their homes. 40 feet difference. Imagine a bunch of water getting accelerated down a hill like that. How much damage can it do? So what they've got is a wetland calculated 929,000, and then the total storage is the total for both. You got two, okay? You got a front retention. It's 114,000. You've got the stormwater basin, or the wetland. It's close to 1 million. You combine those together, and you've got over 1,044,586 cubic feet of storage of stormwater up above these people. And so this entire area here is one big retention area, and it's over 1 million cubic feet of retention, and it's there to protect these properties. And you can see that these properties, this starts to drop, and from the high point along the rim to this back here is 44 feet lower. Now, and this is what's really heartbreaking. I'm just going to spend a second on this. This is the wetland right here. You can see that it's adjacent to one of these ravines. So, and you know you're doing a linear park all the way through here. And so you have this opportunity for your staff to be pretty smart and innovative and say, okay, we got a wildlife corridor that feeds directly in here. It comes down, it goes into, right here's the beginning of the Lake Jackson Basin. And you had this whole direct, both wildlife and water connection to infiltration for your urban development. I mean, it's like the busiest intersection in North Florida, I tell people. It's busier than anything in Jacksonville, Pensacola. It's the busiest interchange on all of I-10 in the state of Florida. And this thing is right next to it. And you had this beautiful opportunity to create this stunning, and So they built it. So this is the front basin. This is a picture of it. So this is, it fills with water. It sits with water. And so now they're talking about eliminating all of this and taking all that water and putting it in the conservation zone, into the conservation area. So that's it. I just showed you that. That's stormwater management. That was a picture from right here looking this direction. And so here is what was done. This delineation, this wetland delineation that you see was performed in 2001. The developer has not done one. It's not an issue of fact. It is a set issue of fact by the hearing. They did not do one. Your staff said none was required. They made a policy up that is attributed to this commission. So the policy that they're saying is, well, we don't have to do one when we've done one before and it's been set aside in a conservation easement. We don't have to do one, even though it's 17 years since the delineation. They made it up. You can't find that anywhere in the rule. Ask them. Please say, can you show me where in the rule, if you have a conservation easement, we don't have to do another delineation? Because they haven't done one. I mean, it's so fundamental to environmental science, y'all. This is what environmental professionals and zoning people and staff, they do. Why wouldn't they ask the applicant to at least update your wetland delineation? There's not been one since 2001. Update it. If it doesn't move, great. But you know it did move because you can see that there was a road built right through it. So you know that when you build a road, you take anything, you move it, it's going to shift the water. On this side, you have offices. It's not going to move that way. It's going to move, so you got this down here. It's not going to move that way. Now you got houses and foundations. Guess what? It's going to move this way. We hired Mr. Songer, who did it in 2001. Wonders of Google. I looked him up, lives in Palm Bay. He came in and he says, yes, it's moved 35 feet. Now that was rejected by the hearing officer. It's unopposed testimony. And if you decide you want to accept that testimony, it's unopposed. He's the only expert that's ever offered an opinion on the boundaries of the wetland. And he said it moved 35 feet. You take 35 feet out of this, it kills their entire project. And they'll have to go back and they'll have to do it the right way. So the wetland has moved. We proved that at the hearing with the same guy that did the original delineation. He says, my original delineation is no longer valid. Now, I want to show you this. This is the only thing that protects these people from flood. That's it. Okay, when that wetland, when that 6 acres fills up and it pops off because of a major storm or because of a hurricane or whatever, this is where the water goes. And this is the way, has to have the capacity to drain 6 acres. It's never been studied because guess what? The natural features inventory hasn't been updated since 2007. The wetland delineation hasn't been updated since 2001. The environmental resource permit hasn't been updated. Nothing has been done by this applicant. And this is what we're dependent on. This has never been studied. The staff can't point to anything that shows that it's ever been studied. This has got to have the capacity to carry the stormwater off, or these people's houses are going to get flooded. So the findings of fact are stormwater management facility number 1 was designed to retain the additional runoff from the first 500 feet up to the 100-year 24-hour storm event. So we know that that big pond that's up there now is designed in accordance with the code. And they're going to change that. They're going to eliminate it. It was designed to mimic the pre-development conditions and only discharges to the wetland and then therefore to the neighborhood in the 100-year 24-hour storm event if it's exceeded. If discharged, the water would go through the drainage easements and then down the hill into Lake Jackson, which is a big no-no because you have interbasin transfer. So now you're just, if you approve this design, you're just going along with that. Now, these are directly from the hearing officer. I've not altered these. I don't want anybody to think I've altered these. These are what was decided by the hearing officer. The application for the project did not contain a new NFI. That's what the hearing officer said. The judge said that. As a matter of policy, I don't know. Do y'all really have a policy that says Leon County does not require submission of a new NFI or a new wetland delineation once previously delineated wetlands are under perpetual conservation easement that is dedicated to Leon County as a preservation area? Is that really your policy? Do you really have a law that says that we're not going to require an NFI and a new delineation? I don't think you do. Your staff's making stuff up because that's not what the law says. Leon County's interpretation that the code does not require an applicant to submit a new NFI for development on a site with an existing NFI and recorded perpetual conservation easement is reasonable. That's your job. You're the commissioners. Y'all make the rules, not them. Staff doesn't do that, and that's not what your code says. Your code says you got to have an NFI. Your code says you got to delineate the wetland. Your code says you got to have an environmental assessment. So I've quoted some case law, and it says essentially the staff doesn't have the authority to prepare draft policies, and that's what they're doing. They're coming in and they're drafting policies for you instead of following the law, and I think I'm proving that pretty effectively right now. So the pending application has not updated the natural features inventory and environmental impact analysis since it was prepared in 2007. I mean, don't these people that own these homes, don't they deserve better? Seriously, you got, each of those homes is $350,000. There's 19 of them. That's over $6 million worth of personal assets. Is it really asking too much for this applicant who's going to make millions to update his environmental assessment? Please. Is it unreasonable to update your wetland? Is it that difficult to hire a scientist to go out there and do the job? So this goes into every application shall be accompanied by an environmental analysis, which shall become part, and upon approval, a part of the final development approval. The environmental analysis shall include the following components. Natural features inventory shall include. Your staff didn't have an NFI. It's using the same one that back from 2007. Your staff didn't do an environmental impact analysis. Okay? They didn't follow the law. You law and order people because they didn't follow the law. So you got closed basin standards. So you have a closed basin there, which I've already shown you the photographs. There's no closed basin. So they made that up too. It's just a horrible mapping error that really was a tremendous asset that's just blown. That the difference is approximately, so here the hearing officer states overtly there's going to be 9,650 cubic feet discharged onto their land. You're going to use their land to discharge their stormwater. Now, they don't have an easement. They don't have a right. So no statute, ordinance, rule requires a wetland to be redelineated after it has been identified and placed in perpetual preservation. That's the finding of fact of the hearing officer. Where does your law say you don't have to do a new delineation because Section 373.421 Florida statute says that the delineation is not good not to exceed 5 years. Well, 2001, 2017, that's more than 5 years. So the staff's in violation of the statute. And your own rule, Section 10-4.322 says determination of the actual extent of a wetland area on a development shall be made by a qualified professional retained by the applicant. Doesn't mean back in history in 2001. It means what it says. The law says what it says. It means what it says. It says retained professional by the applicant. That's not the case. Those are not the facts. That's not what happened. It's not in the record. It's not on the proposed recommended order. The code's rate provisions do not apply. And it says because they're putting it onto somebody else's land, there's a prohibition against the discharge. So, and then this is other arguments raised by the petitioners, by us. Such allegations of trespass, because we claim they're trespassing on our land, use rights pursuant to drainage easements or stormwater facilities reflected on the plat and compliance issues surrounding the previously approved and constructed stormwater facilities are not issues within the scope of this proceeding. So you have an administrative law judge that didn't even address the issue of trespass. So your staff hasn't even addressed, we're just going to let them put our water on your land. Yeah, it's a trespass. We don't care. Hearing officer doesn't care. ALJ hasn't ruled on it. That's right. This is a quote out of her order. So let me leave you with that. Because I'm tired of these people. I'm telling you, it's so unbelievable that you have a local government that is supporting so vigorously this developer to discharge their water in this unique environment, this really unique 6-acre wetland that was set aside by you in a conservation easement. And now you've got your staff telling this developer, just use it as a stormwater pond. And eliminate the capacity that's up above these people that live downhill from it. And you don't have an easement, you don't have any use rights. I mean, guys, this is genuinely wrong. And I've been fighting this fight for a long time, but they are wrong. Thank you for your attention. I really do appreciate it.
Thank you, Mr. Attorney.
Mr. Chairman, at this juncture, it is an opportunity for the other side, if you would, to make argument before you. It's my understanding that Mr. Hall, Doug Hall, on behalf of the applicant, is going to go first. And so that's who you're seeing at the lectern now.
Good evening, Doug Hall, Carlton Fields Law Firm, representing Palafox LLC as the applicant. Mr. Braswell said he's tired of this. We're tired of it too. It has been a long slog. We've been in litigation over this project for 3.5 years. This project was originally approved by the county staff in 2015. An administrative hearing was requested then. That got derailed because the Braswells in that raised an issue based on a restrictive covenant, argued that this property can't be used for anything other than commercial. And so the only place to get that decided is circuit court. Off we go to circuit court for 2 years, including a trip to the First District Court of Appeal. The upshot of that was that there is no restriction. And that litigation is now concluded. That paved the way to resubmit the same application. Your staff looked at that again, approved it in February of this year. We've had a 2-day administrative hearing where Mr. Braswell got to submit his evidence, make all of the same arguments you've heard tonight, make those to an independent administrative law judge, a very experienced lawyer who's worked in the administrative law area for many years, and the short answer is she rejected all of those arguments based on the fact and the law. And it's a fairly narrow standard of review to this board tonight. You can only change or reject those findings of fact if there's no evidence to support them. We didn't hear any argument about that. There is evidence to support all those findings. You can only reject those conclusions of law if it's clear that the ALJ made a mistake. The ALJ didn't make a mistake. These are all solid findings. So we're here tonight after a 2-day trial. We have tried to get this resolved. We haven't been able to do it. We did a full day of mediation over a year ago with Carlos Alvarez. We still couldn't get it done. And really, the problem has been is that these petitioners do not want townhomes near the entrance to their subdivision. And that's what we're fighting over. This isn't about stormwater. This isn't about flooding. The only evidence, the only competent evidence in the record shows that the difference in the elevation of that wetland after you discharge this water into it using the exact same system that the residents on the other side of the wetland are using the exact same stormwater treatment mechanism and discharge into the wetland. The difference is going to be something like 3/100ths of an inch. Now, I'm not sure that's equivalent to the thickness of a piece of paper. It's certainly not going to impact that wetland. It's certainly not going to raise the elevation of that wetland in such a way that it's going to create flooding in this subdivision. You saw from Mr. Hampton a picture of ducks swimming in his backyard. What he didn't mention is that half of his yard is in that wetland. There's supposed to be water there. That's what he bought. And so, half of those lots are in that conservation easement, and there is a pop-off. There is a fail-safe. That's the grate that Mr. Braswell showed you. If the water gets up too high, before it's going to get into anyone's carport or into anyone's home, it's going to drain into that grate, and it's going to go west into another stormwater treatment facility. So there are several fail-safes to keep this thing from flooding, and you heard Mr. Hampton already say, it's worked. It's kept us from flooding. So there's no question here about this project that's going to create flooding. There's no problem with this stormwater treatment design violating the code. It doesn't violate the code. The ALJ found that it doesn't violate the code after a 2-day hearing. The drainage easement issue, the wetlands issue, those are technical issues that are just raised to try to stop this project because that's the goal here. Just make it go away because we don't want this development near the entrance to our subdivision. So I'm here mainly to answer questions. This has been a long slog. We're hoping that this is the last stage of it. We did have a 2-day trial with a lot of the same arguments being made, a lot of evidence on it, very detailed attention given to it, and the ALJ ultimately issued a recommended order that we believe is exactly right on the facts and the law. And we'd ask that you adopt that recommended order in your final order. And unless you've got questions for me, which I'll be happy to take a stab at, that's all I have. Thank you.
All right, Mr. Chairman, at this juncture, we utilized an outside firm to represent staff so that we could remain a neutral to the board. And so Carly Schrader with the Neighbors Giblin and Nickerson firm now has an opportunity to address the board, again, from the staff's perspective.
Ms. Voss, how much time does she have left? How much time does she have? They were splitting at 20 minutes. I guess you got 10? Okay. No, they split the 20 minutes. So she has the remainder, whatever the last gentleman didn't use, I would imagine. I'm sorry.
Actually, the applicant gets 20 minutes and the staff gets 20 minutes.
I'm sorry.
But I've been assured that you won't exceed that.
Can you answer her question then, Mr. Turner? Sure. She said, why does she get 20 minutes as well? I guess because she is not.
Because they're separate parties.
Go ahead, Mr.
Jeremy,
yes.
The petitioners get 20 minutes. However, they wish to utilize the 20 minutes, and they allowed Mr. Braswell to argue on behalf of Ms. Braswell, but they get one 20-minute slot. The applicant gets a 20-minute slot, and the staff gets a 20-minute slot. That's how those times are divvied up. And again, I'm pretty sure that Ms. Schrader's not going to use 39 minutes. So,
Mr. Turner, just for the record, just to show fairness for people that are here, who've never been to this type of quasi-judicial hearing, is that different than any other quasi-judicial hearing that we've done here in Leon County?
not for these types of appeals, no.
Thank you. Ma'am?
Yes, Carly Schrader, the law firm Neighbors, Giblin and Nickerson, and like was said in the introduction, we represented staff throughout the quasi-judicial hearing that was held before the hearing officer. At this point in the process, as the applicant has stated in his argument, the standard of review greatly limits this board and what can be done at this point in time. The hearing officer finds the facts as part of the quasi-judicial hearing, and the board is bound by those special masters finding the fact unless the findings are not supported by competent substantial evidence in the record. So the issue is not whether there's facts that would support petitioner's position, but whether there's competent substantial evidence to support the findings that were made of the hearing officer after she heard all of the testimony throughout the course of the hearing. And during petitioner's argument, there was a lot of reference to materials that were outside of the record that were part of the presentation. There was not reference to the standard of review, and there was not argument that particular findings of fact were not supported by competent substantial evidence. In this case, we believe that the hearing officer's findings were supported by competent substantial evidence. As part of the hearing, the members of the staff testified, including Nafala Ezagagi, who is the environmental review supervisor, who was charged with reviewing the EMP that was submitted as part of this project. The Market District Housing was originally submitted back in 2014. The review began at that time. The county staff performed an independent review and analysis, was the testimony. Back in 2014, when those materials were submitted deficiency notices to the applicant, which the applicant complied with submitting additional materials. There was a back and forth in the process at that point in time. Once the litigation was concluded that was referenced, there was a resubmittal of a new application in April of 2018. And so there was also some additional review, independent analysis at that point by the county staff in terms of the stormwater and other issues that were relevant as part of this proceeding. One of the issues that was attacked at the hearing by the petitioners was the stormwater plan for the project. And the ALJ in this case credited the county's witness who testified regarding the county's code and what those standards are for stormwater in this case. And the testimony was that there was a two-step approach that was used in this case in order to comply with the county's stormwater standards. First, there was a detention pond that was designed to treat the volume determined from a 1 1/8 standard that applies under your code. So the pond holds back the water initially, and then it's slowly released over time through a sand filter and then the second step to show compliance with the county's volume is the county's volume control standards. The applicant had to demonstrate retention with the system as a whole on the site, including, in this case, the wetlands area. And there are various provisions of your code that does allow for retention in the closed basin area in this case. And as you've heard, there are homes on the western side of the conservation easement area also. Lots 11 through 19 also they contain a drainage easement area that has stormwater management features that very much like this project have a detention facility with a sand filter that at the end of the day it drains to the wetlands. So this is consistent on both sides. This is consistent with the homes that were built as part of the subdivision earlier in this case. And so the ALJ credited this testimony and found that the county showed compliance with the stormwater standards at the end of the day. One of the other issues that's been discussed here today is the issue of the conservation easement and the wetland line. The conservation easement was recorded back in 2006, and that was based on a natural features inventory that was approved in 2006 by the county. And in 2008, when the Palafox Plat subdivision was platted and recorded, that conservation easement was included within that plat. And so the development of the subdivision road that leads in and the 19 home sites was all done in reliance on that line. So when those homeowners came in the 2012, 13, 14 time period, they did not have to show a new wetlands line. They came in compliance with the conservation easement line that was recorded in 2006 and reflected on their 2008 plat. They didn't go back and have to prove up that wetlands line. So similarly, in this case, the applicant, the ALJ found, based on the testimony and based on the code, that the applicant did not have to come in and reprove up that line that was approved back in the 2006 time period. In this case, the code does not show that there's an expiration of that NFI that was earlier approved, especially in the case where you have infrastructure that went in reliance on that line. So it's treating this the same way as those 19 homes that developed also in reliance on that line. Now, there were some conclusions of law also that there's no statute, no ordinance that requires the NFI to be redone for the wetlands line to be redrawn at this point. And there's nothing that petitioner has shown at this point that does have to be redone. So the ALJ's conclusion of law in that case is not erroneous, which is the standard that the board would have to find in order to reject that conclusion of law. One of the other issues that the petitioner has discussed at length today is the trespass issue. Now, this is an issue that the ALJ determined is not relevant to these proceedings. And this is a trespass is usually something that's brought in circuit court. Now, in this case, the county's code is clear that the discharge to the wetlands is allowed in this case. There was testimony that the change was insignificant in terms of the elevation, as you've heard the applicant talk about today. This was less than half an inch in elevation change, did not come close to the pop-off or outfall elevation in the conservation easement area, and there was testimony that that would continue to function as it always had, and that pop-off was there, so that in the case that there is an elevation that it drains off at that point, but the county only regulates up to a 100-year, 24-hour storm event, and this change in elevation doesn't get close to that in this case. And that was shown in the testimony of the county's witnesses. The petitioners did have testimony of an expert engineer in this case. However, that engineer performed no calculations and did not have any analysis to show any adverse impacts in this case. At the end of the day, the record supports that there's no adverse impacts to the wetlands, that there's no downstream flooding impacts that's going to result as part of this project based on the county's review of the application materials that was submitted by the applicant in this case, both in 2014 and then again in 2018. At this point, the county staff would ask that the board enter the proposed recommended order submitted as the revised attachment number 1, adopting the recommended order and approving the market district housing site and development plan subject to conditions outlined in that preliminary decision. And I can answer any questions that the board may have at this point. Otherwise, I appreciate your time and your attention today.
Thank you, ma'am. Mr. Attorney.
Mr. Chairman, that concludes what you would get as presentations. It is now for the board to decide, and I'll be glad to help you along if you need any help. So,
Mr. Attorney, any questions that we have, we can address to any of the petitioners or to you, or how does that work?
You cannot take new evidence into consideration. You are limited, as the folks have said, essentially to make sure that there is evidence in the record that supports the findings that the administrative law judge found, and to determine whether or not the administrative law judge made some sort of incorrect conclusion of law. So taking testimony, or if you would, asking staff, that's done. That was done at the hearing.
Got it. Yes, sir. Commissioner Daly.
I appreciate it. And the young lady that just spoke from Neighbors, I do have 2 questions of clarification, if you don't mind.
Sir.
Thank you.
Point of order.
Mr. Turner.
Questions of the lawyers who argued are fine. They're just questions about what the presentation was. So
Clarification.
Point of order.
Point of order, yeah. I have looked through these rules, and I don't see that there would be any prohibition against the commissioners asking the attorneys questions.
I think that's
And
what
that would be my position on that. And
Mr.
so
Attorney.
if there are questions or
that's
something.
what I just said,
commissioners-
but you can't take further evidentiary testimony.
The attorney has said we can ask questions of the
Okay.
attorneys. Yes, sir. Ma'am. Commissioner Daly.
So the 2 questions that I have for you, in the
Okay.
explanation of the judge's interpretation, comes specifically from the argument that was brought up regarding trespass and the water on. And number 2, the natural features inventory. I've got the attorney for the petitioner when it comes to the natural features inventory, flat out saying that the truth was not told by our staff. That they were supposed to do another NFI, okay? But the judge said, obviously ruled, no, the original NFI does stand, correct? Am I understanding this correctly?
Yes, so the ALJ, at the end of the day, concluded that there was not a need to redo the wetlands delineation or to have a new NFI submitted under the county. And it was an interpretation, basically, at the end of the day, of the county's code.
Okay, so the administrative law judge interpreted the county's code that the original NFI that was taken stands in this particular hearing. I'm understanding that correct?
Yes, so the county can rely on that 2006 NFI approval for purposes of this permit application.
Okay. The next question comes to the question of trespass, as it was mentioned. And it's not so much the volume of the water and the impact the volume would have, as much as the water actually being on the property. Remind me and help me understand what was the ALJ, and by the way, I'm not an attorney, if you can't tell. So I'm trying to understand all the legal elements of this. What was the interpretation of the ALJ of why the water could be discharged into the conservation easement?
Yes, so at the end of the day, the ALJ, the conclusions of the law were that trespass is really an area that is outside of this process. The standard in this case is whether there was compliance with the county's code. And under the county's code, there are particular provisions that deal with discharge into the wetland and allow for that in certain circumstances. And so the ALJ reviewed those provisions of the county code and determined that those allowed for the discharge in this case. And just to clarify, the properties in lots 11 through 19 that are on the western side of the conservation easement, they also have a stormwater management facility with a sand filter that's a detention facility where the water it goes and flows into the conservation easement also. So this conservation easement that is partially on Lot 1, Block B, partially on Block A, which is homeowners association property. So both sides of the closed basin drain down into the closed basin. And so the same standard applies for the project as applies for those lots 11 through 19 that are on the western side.
Okay, thank you.
May I have an opportunity to respond briefly to that?
Briefly, yes, sir.
Let me explain the difference. When it was designed by the original developer, which is Asbury, who I think y'all have had some other issues with, is that the backyards of these does in fact utilize a swale system that discharges into the wetland. The front parcel that they're trying to develop was designed to hold the 100-year, 24-hour storm event. 10.9 inches of rain, 10.6 inches, something like that. So before it discharges, so they're not talking about, when it was originally developed. We're 11 years down the road. They have not had the right to discharge any water into that conservation easement. They have not had any right to discharge onto our land. It was all done as a unified plan where the original developer, the guy that put the whole thing together, said, I'm going to do a little bit of drainage down to the bottom. I'm going to put these backyards into the wetland, and I'm going to not allow anything from the front parcel to go into the wetland. It's been that way. You are approving tonight not only a slight increase, but the 100-year, 24-hour storm event, now they're not retaining anything. It's all detention with filtration. We're talking 98,000 cubic feet of water is held on their property currently and only discharges to that wetland under the worst storm, only one in the last 10 or 12 years. So what they're asking you to do is allow you to ignore that and discharge 100% of their water into the wetland. They've got to retain it all now. They're not retaining one drop. Big difference. And they're doing it 12 years later, and the fact that you have a couple little neighbors in their backyards that go into the wetland is completely different than allowing 39 units and driveways and everything to use that conservation area as a stormwater basin, because that's what they're doing. They're going to put 100% of their stormwater into that conservation area. Big difference between a couple little houses using their backyards. It's not comparable. Don't be fooled, please.
I have Commissioner Deloge and Commissioner Dozier.
Thank you, Mr. Chair. I have lived for 25 years as the crow flies, probably half a mile from this location, on the other side of the ravine, basically. I've walked the ravine, run the ravine, and I've watched the neighborhood kind of explode over the last 25 years. I mean, when I moved out there, that was out a little bit. It's changed, and I think we've got a process here and we've got rules here. And having watched this over the years, you start to get a sense of how it works and what works. I'm not an engineer. I'm not a lawyer. I'm not going to hold myself out as a stormwater expert who's going to do all the calculations about how the water's going to flow. What I am familiar with and pretty comfortable with is that we've done this enough within the realms of our staff and growth management that I have a high level of confidence that they get it right. So that didn't seem to satisfy some of the people here, and so they decided we would go to DOA. DOA seemed to confirm everything they said. I mean, if I listen to some of the comments, and with all due respect, it sounds like our staff is possibly incompetent. We're making up rules or ignoring rules. I find that a little hard to swallow, having sat in this seat for 12 years and watched what's going on. I'm real proud of what goes on, and we make mistakes like everybody else, but in theory, that would have been caught by the next level. So I know the traffic issue has been looked at. I'm confident the stormwater issue has been looked at. I'm confident the school capacity issue has been looked at. These are things that we deal with every day, every time we open the door. And I know a lot of my neighbors in Hawks Nest are going to probably say this is something, it's just going to eat up some more capacity in our area, but there are plenty of people that want to live in that area. And so I feel confident that the work's been done and it's been done right. So I'd make the motion to approve as it's been presented.
Option one's been moved by Commissioner Deloge. Is there a second? Seconded by Commissioner Dozier. Commissioner Dozier, you have the floor.
Thank you, Mr. Chair. Commissioner Bailey and Deloge, you asked the questions that I had and made a few of the comments I had, so I really appreciate that. It sounds like we might be on the same page. So I will just piggyback on the comments you just made, Commissioner Deloge. This is the third quasi-judicial hearing, I think, or fourth, that we've been through since last December. We've had a massive amount of information and public participation. And Ms. Braswell, this is the first time I've heard people take issue with staff's interpretation and get pretty upset about interpretation or intent of past policies. I have never once heard that our staff made anything up. And I agree with Commissioner Deloge that if that had happened, I'd be astonished first. But second, I think your comments are an indictment on every professional outside the county family and inside in our court system and everyone else. And I think that's unfair. And so I really do want to say that. I am 1,000% for checks and balances. And I am glad that we have a process. Someone made a comment about public hearings earlier. We have public hearings when we change policy, when we change zoning, and get into it pretty deeply. When it's an application of current rules, that's the question on the table. We can't review every single development that comes before us. So I'm feeling a little defensive right now of all the professionals, public and private, who've been involved in this, and I fully respect the neighborhoods who are concerned about some of these developments and their approach. But I think we have to respect all of those different sides when we come into a setting like this. With that, and I'm happy to support the motion. So, Mr. County Attorney, I understand we're just looking at the finding of fact, if it meets the rules, all of that. This is outside of that, and again, both of you just mentioned this. We're looking at traffic and new blueprint projects and stormwater projects every day. And so the last comment I had was this idea of water trespass just astonishes me. I went to the property appraiser's website, and I think this is a real slippery slope, so I think it deserves comment. I'm glad you asked the question, Commissioner Daley. If we talk to our friends in Buck Lake right now, who have water being drained from Pedrick Pond out through, if we talk to Carlos Alvarez, who is an advocate for Lake Lafayette or others, the idea of water moving through our community and being able to trespass on someone else's property within a area that isn't owned, I mean, the lots only extend a little bit, that is a real slippery slope. And I think it would be in our interest to kind of put a stop on that if we're going to hear that in the future, because we've got a lot of water in our area and it's going to move. We all know that. And we are working hard. Our staff is doing a great job addressing that. So, again, these quasi-judicials always bring up a lot of other unrelated issues, so I wanted to comment on those. But I appreciate everyone's time on this, and I hope this brings it to a close tonight after 3.5 years. Thank you.
Thank you. Commissioners, I have no more commissioners in queue to speak. We'll move to a vote.
Mr. Chairman, let me just put on the record that the motion, I hope that the motion from Commissioner Deloge was for the amended staff recommendations 1 and 2. Okay. Thank you.
Commissioner Daley.
For the record, walk us through the amendment. Everybody's on the same page. The amended recommendation of option 1 and 2.
It's to approve the final order, which adopts the recommended order from the administrative law judge with the addition of the exceptions being struck.
Mr. Attorney, my only question is, have we already taken up the motion to strike the exception?
Yes, but we're including it in the final order just so that there's a written piece of paper.
Okay. Everybody understand what we're voting on? Motion on the floor is made by Commissioner Deloge, seconded by Commissioner Dozier for staff recommendation as amended with the inclusion of the striking of the exceptions in the final order. All those in favor of the motion on the floor indicate by saying aye. Any opposed? Motion carries 7-0. Thank you. We'll move now to citizens to be heard on non-agenda item. Mr. Administrator.
We have no speaker cards.
We have no speaker cards. We'll go to Commissioner discussion time. We'll start with the attorney.
I have nothing, Mr. Chairman. Thank you.
Yes, sir. We'll go to the administrator.
Thank you, Mr. Chairman. I have nothing.
All right. We'll start with Commissioner Lindley.
Thank you very much. I just have one item. The new director of the Domi Station, Antonio Montoya, would like to make a presentation to us to let us know what's going on at at some future meeting. Pardon me, at Domi? Did you not? I'm sorry. Yes.
Yes, is there any
We'd like
objection?
to put that on an agenda for him to make a presentation.
Yeah, is there any objection to that? Show Commissioner Lindley making that motion, seconded by Commissioner Dozier. Accepted unanimously. Commissioner Lindley.
And that's all I have. Thank you.
Commissioner Dozier.
Thank you, Mr. Chair. Good meeting today. We can make the archaeologists and building community and others all happy in the same day. I'm pretty happy, just thinking about that during break. The resolution request, and actually I'll frame it as an agenda item request that I referenced earlier when we had the item on PSCC. It is something that I mentioned Karen Woodall working with Southern Poverty Law and a group, and a partnership under, they have a hashtag, No Place for a Child, is trying to get resolutions to change state statute relating to who can charge a minor as an adult versus a child and when. This is called a direct file resolution. It is complicated. Apparently the chair has heard about this and maybe some others. There are different opinions on this. I think the State's Attorney Association is not in favor of the change, although individual state's attorneys may be. I'm not sure where State's Attorney Campbell is. I'm not sure where our sheriff's department or our sheriff is or others. So I think I am sold that this is a good thing, that to help address issues in how minors are charged and when and how they're charged as an adults. But I do think you all, or we all, may benefit from an agenda item coming back. They're looking for people to do the resolutions in October because that's Juvenile Justice Month, I believe. I don't want to force that issue for sure, but I was hoping we could get the agenda item back in October. So my motion would be to bring back an agenda item with a discussion of resolutions on direct file.
Yeah, I'll second that, Commissioner Dozier. Thank you for bringing it up. Last year, the reason I was perked up when you said is because I had opportunity through my leadership with FACT to hear a representative from down south, I forget the young lady's name, but she filed a bill to deal specifically with this issue. And commissioners, if you don't know about it, it's pretty, it'll break your heart when you hear about some of these cases, how these kids are being charged as adults in some of these cases, and it really will seriously break your heart. So I look forward to seeing that come back. I look forward to also supporting that resolution because this is something that we really need to do, but not just us. I think the state needs to take charge of this issue and really do something about it. In the agenda item, Commissioner Dozier, would you like for, I guess you asked for an agenda item, not a workshop, but I was wondering, I would actually like to hear what the state attorney as well as the sheriff would have to say about this issue.
Yes, sir.
Thank you.
Thank you, Mr. County Administrator. Yes, Mr. Chair, I was hoping that an agenda item would give us an opportunity to reach out to Sheriff McNeil, to State's Attorney, to others, and hear their thoughts on this. It is a complicated issue. I respect what my understanding is of the State's Attorney's perspective. They get to make the choice on when to direct file a minor as an adult. But there are a lot of other questions when Department of Juvenile Justice might play a role and others. So I think this is important and it's in line with other things that we've mentioned. So yes, my request would be for an agenda item in October so we can discuss it and, if possible, move forward with the resolution.
Perfect. All those in favor of the motion on the floor indicate by saying aye. Aye. Any opposed? Motion carries. Commissioner Dozier?
That is it, sir. Thank you.
All right. Commissioner Proctor?
Thank you very much. I want to acknowledge the presence of Leon County's Clerk of Court, Wynn Marshall, who sat through that last hearing. So that the clerk follows courtroom proceedings from the 5th floor down to the 1st floor is pretty remarkable. And clerk, you have a lot of differences to listen to in this building. A lot. I recognize our clerk. Chairman, we have scheduled a workshop on Tuesday, the 23rd of October, and it's to deal with our state and federal legislative priorities. And consistent with what Commissioner Dozier recommended prior to our break, I would like to ask staff if we could look at potential grant or funding issues for LIFT and Ready to Work, and that items 1, 2, and 3, which we adopted staff's recommendation that in the year 1920 we might merge a couple of groups
And I'm just hopeful that we could make room on the meeting of the 23rd, when we look at the state and federal legislative priorities, if we might also look specifically at some grant opportunities consistent with Commissioner Dozier's ask previously.
Yeah, Commissioner Dozier, do you mind seconding that, or do you staff just need direction on that, or?
That could be, if that could be included as part of a motion to bring back with the workshop packet, that would be great.
Well, we're looking at money that day, and since money is what we're seeking for the LIFT and the other programs.
As I understand it, you're speaking on the point that Commissioner Dozier made earlier about us looking for grant funding for those types of programs, correct?
Mm-hmm.
You want to speak to it?
Mr. Chair, this is, I don't have the workshop on my calendar. I assume it's a legislative priorities workshop. Is
Yes,
that correct?
he wants to include that.
Yes, I think as a priority in our, in our legislative discussion, I would welcome that addition. I assume it might take us a bit longer to assess where we are with whether it's CHSP funding or reentry funding. And so I'm fine with those items coming back in the spring. But if we could have an update to keep it alive as part of our legislative priorities workshop, I think that sounds good.
All right, that's the second. Any objection? Commissioner Proctor? Short pass.
What was that? What you said?
It's short as pass.
Oh, pass. Sure, show as pass. Okay. Chairman, I wanted also to ask staff for a copy of our last Fairground Citizens Group report and the report which came to us from a consultant Dump years ago. And I don't know where my copy is, Vince, but I would be curious as to whether I could receive your copy.
Mr. Administrator, can you give me a date on how long ago that was?
Excuse me?
When was that study conducted?
It's, Commissioner Proctor's right, it's been a while. We conducted a market feasibility analysis. There's two. One was, both of which have spanned the time since Commissioner Proctor's been here. One was about 20 years ago, one was probably closer to 10 years ago.
Okay, could you, I mean.
We'd be happy to provide those documents.
Yeah, could you provide them for the dais? Because I'm pretty sure only people that are probably here are maybe Commissioner Proctor, maybe Commissioner Lowe's, Commissioner Daly, maybe?
We'll be happy to get all of the reports to all the commissioners.
Okay, thank you.
One of the things as notation unique that has occurred since the last feasibility study was that study recommended that we wait for Southwood to develop and flourish and blossom. Most of the things, the trends of which that study was asking for prior to our actually viewing the fairground as a ripened site to sell women's stockings and, a job mustard, was that Southwood needed to fill out. And I think that since that time, Southwood has filled out. Also, with respect to that market study, the new Veterans VA clinic has opened in that geographic sphere. There have been new apartment units built just west of the Veterans Administration Clinic, hundreds. Coming around Blairstone, commissioners, there are loads of brand new apartments and housing that is coming online. And so the feasibility study that we're seeking, it seems like that study was asking for a market of people who were uniquely not as poor as those who were the people who live around the fairground presently. It seemed that the desires of shopping and opportunities and options of the market consultant did not value very much people who lived in Appalachia Ridge or South City and all those other neighborhoods around there. So I wanted to make sure that we were aware that there's a a new gentrified kind of community member that's in that market area. And I think that that should be illumined and lifted as we look at it, hopefully again. I know that when it comes to outdoor uses of bathrooms, that no one here finds that offensive but myself, but that we own property, that we ask the public to go outdoors to use the bathroom, it offends me. And in particular, that it occurs in District 1. And I'm not sure that we have a public facility that we allow that in any other district that I'm aware of as known and as used a facility that we, through our non-feasant demand for the public to use outdoor bathrooms. So I'm appreciative for that information, Vince, if you could bring it back to me. Thank you very kindly. Chairman, thank you very much.
Commissioner Daly. Commissioner Deloge.
Real briefly, a lot of people have asked how Brenda's doing. I know Deb has kept up with her. She left a couple of weeks ago. Her daughter and granddaughter were in a really bad accident in Costa Rica where they live, so she is still there. We'll be there till late this next week. My sense is she'll come home and probably go back after a while, but thanks for your prayers. And I wanted to publicly thank Stephanie, who has backed me up, and Vince for helping me, and for all the other people up and down the hall that have stepped in. Thanks. Appreciate it.
Our thoughts are with Brenda, for sure. Mr. Vice Chair.
Thank you, Your Honor. I mean, Mr. Chair.
Very funny.
He did spur some wins.
You did good, man.
I tried,
I was
man.
impressed. Yeah.
Hey, John, man.
No bond, I would have bought it.
Just roll with it, baby. Just roll with it.
Mr. Chair, I do have a request for a proclamation for a healthy start. Proclaim the month of October as SIDS Pregnancy Infant Loss Awareness Month. Proclamation, hopefully we could share it before their walk of remembrance at, I think it's the 16th.
Any objection? Motion made by the Vice Chair, seconded by Commissioner Lindley. Charge is approved.
That's it, Your Honor.
Thank you. Mr. Vice Chair, thank you for covering for me today. Like I said, people said you did a great job. Great job. I was listening to you on the way in. Except for that coffee that you spilled. You got a little nervous. Great job today. As always, I enjoy spending time with this board and being on this board. Very proud to be a part of Leon County. It was good to hear the comments from the commissioners when it came to our staff and the job that they do and the integrity that they do it with. Because they we're not talking about Vince. We're talking about staff. Vince, no, we're talking about him. But seriously, I appreciate the commissioners giving the staff the nod that we believe in what they do and the integrity that they do it with. I have one proclamation request. I would ask somebody to make the motion for me for a proclamation honoring Leon County Volunteer Firefighters Day to be presented outside on October 13th at the Fire Truck Roundup. Motion made by Commissioner Lowe, seconded by Commissioner Dozier. Any objection? Showing none, we will call it approved. That's all I have. Is there a motion to adjourn? We adjourn.